Hi, I'm Rebecca. I'm a solicitor director here at Wendy Hopkins. I'm going to talk to you today about coercive controlling behaviour. As a family lawyer, we're hearing the terms coercive and controlling now more than ever. The difficulty is because coercive controlling behaviour, it can be really devastating in terms of the impact it has on the victim, but it is also really difficult to prove. Coercive control is a criminal offence, and this has been a welcome change. It was made an offence in 2015, and the Serious Crime Act section 76 created the offence of controlling or coercive behaviour in an intimate or family relationship, but it did not define the behaviour in any particular context. It's there that the difficulty arises in family law. Looking at what is coercive control as defined within the criminal proceedings, coercive control is when a person with whom you are personally connected repeatedly, and that's a key phrase, behaves in a way which may make you feel that you're controlled, dependent, isolated or scared. The following types of behaviours are common examples of coercive control, such as isolating you from your friends and family, controlling how much money you have and how you spend it, monitoring your activities and your movements, repeatedly putting you down, so calling you names, telling you that you are worthless. Really serious then is threats to harm or kill you or perhaps a child, threatening to publish information about you or to report you to the police or the authorities, damaging your property or household goods, and what we see quite regularly is forcing you to minimise or perhaps cut all family ties. Some of the behaviours I've mentioned above are a list, and they can also be offences on their own. So it could be that the perpetrator is not just arrested for coercive control, but the abuser could be arrested for more than one offence if they are, for example, damaging your property or similar, or making you yourself commit some form of criminal activity. The list itself is not exhausted and should be looked as a wider picture, because what someone finds controlling or coercive, another person may not. For the purposes of criminal matters, the abuser will be guilty of the offence of coercive control if they personally are connected to you and their behaviour has had a serious effect on you, and your abuser knew or ought to have known that their behaviour would have a serious effect on you. In criminal law, serious effect is defined as either causing fear on at least 2 occasions that violence will be used, or causing serious alarm and distress, which has a substantial adverse effect on the victim's usual day-to-day activities. That offence has a maximum penalty of 5 years imprisonment. The difficulty here is proving that in family law away from the criminal courts. In family law, we have seen the family court has quite struggled to grapple with allegations of coercive control due to the hard task for the victim to provide evidence in support of the coercive controlling behaviours and to prove the serious effect. The coercive controlling behaviour alleged as single allegations on their own could be seen as a one-off or perhaps trivial, but you need to look at it as a bigger picture and look at the picture and pattern of those behaviours coming into a play, and then the impact that that's having on the victim. In a recent case of M&F, the judge in that case highlights that there is no legal definition in family law of coercive and controlling behaviour, which is where the difficulty lies. There's very little case law in this area, and as such, that case has been a real welcome change and a welcome development in family law, because the judge in that case did try to shed some light on the definition and also to help family practitioners in recognising with their clients if their client is suffering from coercive and controlling behaviour. There are some guidance out there, and I think it's important to summarise in terms of the definitions of coercive and controlling behaviour. So coercive behaviour is a pattern of acts. Such acts will be characterised by assault, threats, humiliation, intimidation, but are not confined to this and may appear in other guises. The objective of these acts by the perpetrator is to harm, punish or frighten the victim. Looking then at controlling behaviour, again, it's a pattern of acts, and it's designed to make a person subordinate and or dependent on the perpetrator. This is achieved by isolating them from support, exploiting their resources and capacities for personal gain, depriving them of their means of independence, resistance and escape, and regulating their everyday activities. The key to both behaviours is an appreciation of a pattern or a series of acts, the impact of which must be assessed cumulatively and rarely in isolation. What is clear from all the recent developments and the literature is that this form of abuse is continuous. It doesn't stop. It continues to go, and it can be one issue, might be very small on its own, but collectively and continuously, the impact can be relatively devastating on the victim. On their own, each individual act may not cross the threshold, but when taken as a whole, it shows a pattern of behaviour which is coercive and controlling in nature. Therefore, how does someone recognise signs of coercive and controlling behaviour? The difficulty here is often the perpetrator that portrays themselves as the victim to the professionals involved in the matter. They have to be very good at manipulation to be able to actually commit the offence of coercive and controlling behaviour, and therefore will often gaslight the real victim to make them look like they're the issue in the matter and not the perpetrator themselves. The perpetrator's ability to convince and persuade is, of course, what makes them so effective in carrying out this form of abuse. Referring back to that case I spoke about earlier, the judge in that case highlights the importance for professionals involved in a matter to look out and be alive to clues, hints, indicators and triggers in what people are reporting, and look at it holistically, considering what the impact could be on the family as a whole, and whether actually, if you look at this outside of what the perpetrator is reporting, is there then coercive controlling behaviour behind the scenes? As a family lawyer, it's clear that more knowledge and training in understanding coercive control is needed across the section, and the case of MF has been a real positive step forward in recognising the need for change for these victims. And if you feel that you have been abused and are suffering from coercive and controlling behaviour, we've put some helpful guidelines within the comments and contact details for you to be able to report such matters on a confidential basis.